Hi, I'm Maria Bermudez, a disability lawyer with 17 years of experience in Social Security disability law. If you've got a Social Security disability hearing coming up, this video is for you. I'm going to walk you through exactly what to expect so you can feel prepared and confident, because I know this process can feel overwhelming, especially if it's your first time. Over the years, I've supported clients all over the country in video and phone hearings before administrative law judges. And today, I want to give you a straightforward overview of how a typical hearing works, so you're not caught off guard when it's your turn. There are usually three main parts to a Social Security disability hearing. The first part is procedural matters that the judge will address. We call it housekeeping. You'll be sworn in and the judge will confirm that you're okay with proceeding by phone or video. They'll review the exhibits in your case, which are your medical records, notices, and any other documents in your file. And they'll also introduce the people who may be present, like your lawyer, a vocational expert, the hearing clerk, and sometimes a medical expert. In most of my cases, especially in Pennsylvania and New Jersey, medical experts are rare. But in jurisdictions like Puerto Rico, it's common to have one attend at the hearing. Next is your testimony. This is your time to speak and share your story. The judge or your lawyer will ask you questions about your medical conditions, your symptoms, your daily activities, and your work history. The goal is to understand how your conditions limit your ability to work. Judges also tend to ask questions about anything in the record that stands out. For example, if it looks like you worked after your disability date, or if there are earnings listed that may need to be explained, they'll bring that up during your hearing. What matters most here is that you're honest and specific. Don't be afraid to talk about the full extent of your challenges, even if it feels uncomfortable or embarrassing. And it's completely okay to say, "I don't remember," or "I'm not sure," if you don't remember the answer to something. Just speak truthfully. If you want more guidance on how to communicate effectively with Social Security, we have another video all about that, and I'll link the description, and I'll put the link in the description below. After you finish your testimony, the vocational expert or vocational witness, as lawyers often call them, will testify. Their job is to classify your past work using the federal government's Dictionary of Occupational Titles and give the judge an opinion on whether someone with your specific conditions could still do any jobs in the national economy. During this part, it's important not to interrupt. If anything needs to be clarified or challenged, your lawyer will handle that after the expert finishes. Now, just a few final tips. Speak clearly and loudly enough so everyone can hear you and so the recording comes through clearly. Don't just nod your head or shake your head. Make sure you say your answers out loud. Find a quiet, private space for your hearing and make sure you have a strong phone or internet connection. Don't interrupt the hearing unless there's something urgent going on, like you're not feeling well or can't continue. And if you don't understand a question, ask for clarification. Most importantly, don't downplay your symptoms. Be honest, be specific. Talk about what life has really been like since your health changed. The point of the hearing is to help the judge understand why you can't work and support yourself financially. Thanks for watching, and I'll see you in the next video.